postponement. We have prepared written submissions on the question of the postponement, which I would like to hand both to the legal team representing the affected members and the committee. It'll immediately be emailed to the committee, and we have hard copies in the chamber to hand out to the legal team for the affected members. But turning to the first aspect, which is the question of the composition of this committee. The composition of the committee is set out in Rule 154 of the Rules of the National Assembly, which is part of Chapter 12. Chapter 12 deals with the committee system and in clear and unambiguous terms how this committee is to be composed, and the appointment procedures are set out in Rule 155. Now, unless and until those particular rules have been declared invalid for whatever reason, this committee is entitled to sit in the capacity it sits, which is to give effect to Section 12 and 13 of the Powers, Privileges and Immunities Act of 2004. And before this committee or before the High Court, there is no challenge to the rules in this respect. I know our learned friends suggest that there is, but we haven't seen it in the sense that there is this composition has been in place for many, many years. This committee has sat, and it would be interesting, and we would submit odd, for the committee itself to find that it itself is unlawfully or improperly composed. And were there to be such a thought, the best way to deal with it is for the committee to get on with its business and make what is called a finding and recommendation, table it in the House, and thereafter let whoever deems it appropriate challenge the validity of the composition, not by way of just this particular composition, but by way of a challenge to the rule itself. That's how these things are done. So even if the committee is persuaded, which I submit it shouldn't be, that there's any merit in this composition point, it's not available for this committee at this point to take any action by, for example, appointing an independent person like the committee or like in respect of my appointment as the initiator. So the point doesn't get off the ground concerning the so-called unlawful composition of the committee. And this committee we would submit can ignore that point in its entirety. Turning to the question of a postponement, I have prepared written submissions, and let me start by saying our learned friend says that today's application for a postponement is, in his view, not Stalingrad. Well, we would disagree. We would submit that today's postponement on its face is Stalingrad on steroids. I will turn to why I say that in dealing with the application for the postponement as was filed on Saturday evening before this committee. There's no merit to the application, and the underlying basis of the application is unfortunately solely lacking in any substance. May I just check with my team whether the heads of argument have been emailed to the committee and given to our learned opponents? So, Chair, I trust that the committee members have now all received soft copies or by way of email of our written submissions. And I would take the committee to it because perhaps in listening to me, it'll be easier and quicker were the committee members to read my submissions as I proceed. In paragraph 1, we deal with the question of the notice to the 6 affected members. And in paragraph 2, we deal with the content of those notices. And importantly, Chair and other committee members, what is interesting is that the notices were served on the 6 affected members on a Tuesday night. That following Friday night, or not Tuesday night, Tuesday afternoon, but that following Friday evening at 7:24, the attorneys for the affected members drafted a letter to the Speaker and the Chair, and on the Sunday, the Speaker, through the State Attorney, responded. But it's important to note that on the Friday evening's letter, which was written by Ms. Cupido of Ian Levitt Attorneys on behalf of the 6 affected members, certain points were raised concerning why a postponement should be granted, including the question of the High Court litigation, including the fact that there were, for example, 640 pages contained in the bundle, the hearing bundle. And on the Sunday letter in response, all of these points were taken care of, so that, for example, it was explained in paragraph 20 of the State Attorney's letter to Ms. in response to Ms. Cupido, that it's all very well saying there's 640 pages in the bundle, but almost all the pages are formal documents such as legislation, the rules of the National Assembly, joint rules, and there was nothing, open quote, new that the 6 affected members would need any time to consider. So the insufficient time on the basis of the bundle is a non-starter. And one sees in paragraph 4 of my submissions that Ms. Cupido's letter requested certain information. There was a request, rather it was framed as a way of a demand that the hearing be postponed to a date in 2024. Again, after judgment by the Western Cape High Court in a matter to be heard on Monday, the 4th of December, 2023. The committee has heard from our learned friend the similar refrain today, and that refrain is included in the application for the postponement that was filed on Saturday evening. And what Ms. Cupido did in her letter was to threaten a High Court interdict to stop these proceedings, prohibit these proceedings commencing. And the response from the State Attorney was, that is inappropriate. It's inappropriate to approach the High Court, rather approach this committee, which is what they did. But the important point that I want to stress is that the 6 affected members knew as long ago as Friday, the 10th of November, that they wanted a postponement. That's 3 days after having been served the notices. And yet they waited 9 days to bring their formal application, the substantive application for a postponement, without any proper explanation. And it's a factor that this committee will take into account in deciding whether to grant the postponement. They knew early on, so they would argue, that they didn't have sufficient time, but they waited 36 hours before the hearing, they bring their substantive application. And the courts have replete with authorities which say, if you know you're going to bring a postponement, if it's a good faith application for postponement, do it as soon as you know you want postponement. As soon as you're going to make your application for postponement, make it. But if you wait till the last moment, you're almost hijacking the decision maker to say, well, it's too late. We have to now listen to what they say at the last minute. So we take it further, and if I may turn to paragraph 11, it says there is now a substantive application in which a postponement is sought. And we submit that in paragraph 11, that this postponement application is an abuse. It's a clear stratagem of the 6 affected members to avoid taking responsibility for the alleged disruptive conduct at SONA. They wish to evade the hearing and the charges at all costs. They were ducking and diving, and such conduct should not be tolerated. And I may just turn away from the note to make this point. Our learned friend has suggested, and we disagree with the suggestion, that the test for the charge of approaching the president and the speaker in a threatening manner is to be determined on a subjective basis. We disagree with him. It doesn't matter what the president, what the speaker, what the 6 affected members thought. It's what the objective facts show happened at the event. So if the 6 affected members had absolutely benign or peaceful intentions into jumping onto the stage in the middle of SONA, the fact that what was going on through their minds is not an inquiry that this committee will consider. Similarly, what the president thought or what the speaker thought is not of relevance. If the president thought, well, I'm not threatened because I have the VIP protection, I'm not really threatened by 6 people jumping onto the stage while I'm sitting here. Or if the speaker thought similarly, she was at the back end of the stage and she couldn't be threatened because she was quite far from the action, it's irrelevant. So we would submit that it's an objective inquiry, and this committee will draw inferences from the conduct which the 6 affected members were involved in. So the conduct involving the 6 affected members is where this committee will go from an objective perspective. What are the inferences that can be drawn from jumping onto the stage at the time and in the manner that they did so? It's a simple issue. I then turn to the issue of Stalingrad, paragraph 13 of our note. This conduct of delay is classic Stalingrad. The 6 affected members have taken every step, reasonable and unreasonable, just to ensure that the hearing does not commence. On the version testified to by Ms. Cupido on behalf of the 6 members, a postponement is certainly not warranted. So what the committee will do is read and analyze and consider the application by the 6 affected members as testified to by Ms. Cupido. 4 corners of the application are Ms. Cupido's evidence and my learned friend's address this morning, and make a decision on that. Simply put, we say in paragraph 15, the 6 affected members on their version have not made out a proper case to be granted a postponement. And so we conclude by saying at this part of the heads, there should be no postponement. We turn to give the committee some assistance by how the courts have dealt with applications for a postponement. And we start off by in paragraph 14, it's 18, following the 14 to 17 paragraph. But in paragraph 18, we say in court proceedings, a postponement of a hearing is an indulgence. Let me repeat, it's an indulgence. And in 19, that indulgence will only be granted where the party seeking a postponement demonstrates that it is in the interest of justice to do so. That is the burden of a party seeking a postponement. Now, we accept that this committee is not sitting as a court, tribunal, or arbitration forum. It nevertheless has the power to consider an application for a postponement of a hearing. Let me just stop and say, it is suggested that this committee would find the 6 members guilty or not. That's not true. What the committee does is table a report in the House, and that report will include findings and recommendations. The Act, the Powers Act makes it, and the rules make it clear that the House itself is not bound to follow that report. So this committee plays a recommendatory role rather than a role of making a finding one way or the other. That being so, we make the point that when it comes to the question of a postponement and the court's guidance as to how the committee must consider and exercise its discretion, the criteria, the factors that the courts have set out play what we call an a fortiori role in how the committee would decide. In other words, to the extent that a court has a discretion, the discretion is far more narrowly tailored and far more narrowly exercised when it comes to the committee itself. So the committee itself will decide, do we grant this party an indulgence? The committee will consider Ms. Cupido's affidavit with our learned friend's oral address this morning and decide with reference to the factors that the courts have set out, but those factors must be given heightened awareness in deciding whether to grant a postponement or not. That point is made in paragraph 22. In paragraph 23, we submit that a proper case must be made out. So there would have to be an explanation. Now, we've heard from our learned friend that the members, they may wish to call the president, call the speaker to hear what's in their mind. That case is not made out anywhere. It's not in the letters addressed by Ms. Cupido. It's not in the affidavit addressed by Ms. Cupido to this court. So one has to look at what is the application that serves before this committee. And the application doesn't talk to any of those types of considerations of who it wishes to call, who the 6 members wish to call, and why. So one would look at the postponement itself. And we say, as far as being given an opportunity to bring a constitutional challenge is concerned, in paragraph 24, the courts have now put their face against the notion that where there is a hearing, whether it be a criminal trial, a labor dismissal hearing, disciplinary hearing of any type, that a party facing the hearing should be entitled first to approach the courts with a constitutional challenge, and thereafter, if they fail, let the hearing go ahead. Courts have said that's not the way to do it. The general way to do it, have your hearing, and if you are not successful in opposing whatever's happening, if you're found guilty, or if you lose the labor case, or if you lose this disciplinary, then at that later stage, you may appeal the ruling, review the ruling, and bring your constitutional challenge. Not upset the whole apple cart by bringing your challenge and then staying the proceedings for a year, for 2 years, for however long, while this constitutional challenge is traveling through the courts. And the Supreme Court of Appeal and the Constitutional Court have said over and over that way of doing things, of staying the proceedings, obtaining postponement after postponement after postponement, is inappropriate. Get on with your hearing, and if you're not successful, then you can bring your challenge. And that's classically the case like this. So, for example, let's assume the 6 affected members have their hearing, and it turns out that the report is one that the report that's tabled in the House is one that they feel comfortable with. They wouldn't bring the constitutional challenge because they would have been vindicated before this very committee. As it is said, perhaps the committee will find that they didn't jump onto the stage in a threatening manner. They didn't disrupt the proceedings as set out in Section 12. Well, then there's no need for the constitutional challenge to be brought. There's no need for all of the, let's call it, interesting constitutional aspects, the composition of the committee to be considered. And they would have been, open quote, not have any black mark or stamp against them. And the 1 million or so voters who have asked those representatives to be part of the House, they would have had their needs properly considered. So we say in paragraph 26, in this case, the committee may, after hearing evidence and considering argument, table the report in Parliament recommending that no action of any kind be taken against these members. And the members may feel that the inquiry conducted was reasonable and procedurally fair, so there would be no need to challenge its report in the House and the procedures adopted by the committee. Now, the point I want to make here is that to predict that the committee will act in an unreasonable and procedurally unfair manner is unfortunate and not warranted by the facts. This committee will act reasonably, will act in a procedurally fair manner, and it's not at this stage for the affected members to second guess how the committee will run its proceedings. We turn to paragraph 27. It's a point that I've already made. This application fits into the premature preemptive category repeatedly warned against by the courts. The postponement application is inter alia on the High Court in constitutional challenge, and then the arguments again are set out in paragraph 29 and 30. Ms. Cupido's arguments for postponement are premised on the potential unfairness and unreasonableness, not the actual unfairness or unreasonableness. And we say if it's potential unfairness or unreasonableness, that in and of itself is no basis to grant a postponement. This committee would then be suggesting, well, they claim they need more time, they claim there's a constitutional challenge, they claim there's 740 million. We as the committee, we don't think we're going to act fairly and reasonably, so we postpone. It doesn't work that way. This committee will do what it is required to do and continue its proceedings till such time as it finalizes the proceedings. And at that point, if the affected members are dissatisfied that they didn't obtain natural justice, fairness, reasonableness from the committee, it is at that point in the future that they may take up these challenges. So in summary, we say in paragraph 32, the members seek a postponement to await the outcome of some High Court case which may have no relevance or any bearing to this hearing. It is emphasized in paragraph 33 that before the House may take any disciplinary action against a member, the committee must, and it's an obligation on this committee, inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. And if it ultimately transpires that the High Court and possibly the Supreme Court of Appeal and Constitutional Court judgments have some bearing on the reasonableness of this hearing and its procedural fairness, the affected members will certainly not be without a remedy. They'd be entitled at that stage in the future to bring whatever challenge they would want to make concerning the so-called irregularity of these proceedings. And just let me say to the committee that even were the High Court challenge to succeed, that's not the end of the matter as far as the hearing or the fairness and reasonableness of this hearing is concerned. Section 172 sub 1 sub B of the Constitution gives the court wide remedial powers to make any order that is just and equitable in the circumstances. And it may well be, and one can't predict, that were the High Court to come to the assistance of the EFF and the Menti and Marais applicants as far as the constitutionality of that which is being challenged, it may, and we would submit probably would, make a ruling that despite the infirmities of the legislation or the rules, the proceedings would not be regarded as unreasonable or unfair. That would be what we would submit would be a serious possibility as to just and equitable remedy that the court might grant. But it's at that stage in the future that the affected members would have the remedies or rights, which whatever they may seek, to challenge these proceedings. But what they try to do effectively is to avoid even having the hearing commence. And when they do that, one has to look at the substance of the application that was brought. And I've made the point over and over, Ms. Cupido's affidavit are the four corners of the evidence that one will consider, that the committee will consider, and they just do not get off the starting point. In paragraph 58, I've made the point. So, Chair, in paragraph 39...
Chief, I'm calling a point of order.
What is your point of order, Honorable?
His 30 minutes is finished, Chairperson. His 30 minutes is done. Been addressing here for over 30 minutes. He must be organized.
I think I've had 21 minutes, Chair, according to my clock, but I might be wrong. 21 minutes at this point.
He's not talking to you. There is procedure in Parliament. Keep quiet. He's talking to the chair. Why are you talking? Why are you talking when he's talking to the chair? It's not talking to you. That's the problem of white supremacy. That's the problem of white supremacy. You think you can just disrupt us like that?
According to my watch, he's left with 6 minutes.
You want to allow what? Dlagude, you want to allow what? You want to allow what? We're not Dlagude. You want to allow what?
Honorable Malema, please, can you be orderly, please? I'm chairing. Can you respect the chairperson? You may raise your point of order, I will recognize you, but I'm responding to Honorable Ndlozi's point of order that advocate is left with 6 minutes. Can we allow him to proceed, please?
Yes, Chair.
Proceed, initiate.
Thank you, Chair. In paragraph 39, I was suggesting that the comments of the Constitutional Court in a case called National Police Services Union and others versus the Ministry of Safety and Security and others from 2000 should dominate this court's consideration of the application for postponement. In paragraph 4, the Constitutional Court stated the postponement of a matter set down for hearing on a particular date cannot be claimed as of right. An applicant for postponement seeks an indulgence from the court. In this respect, the applicant for a postponement must show that there is good cause for the postponement. And I'll move on to Myburg Transport in paragraph 40, 41, Gravenstone versus Neertling, and in numerous other cases to the same effect. In 43, there's the full bench of the Cape High Court where the application was for a postponement in circumstances where the minister in that case, or the Minister of Home Affairs, had filed no papers whatsoever in a constitutional challenge to legislation. And the court was put in a difficult position because here it was deciding whether legislation was unconstitutional without any papers from the government. And the court refused a postponement partly because the application for a postponement was brought at such a late stage. So the real question is the late application in this case, together without any merit and substance to the application, we say would suggest that there is no merit. In paragraph 48, I've dealt with the bundle, and I've dealt with the difficulty that the 6 affected members have, is that they complained about the size of the bundle when it was explained in correspondence that the size of the bundle was of no moment because the words are, the documents are all formal in nature, such as the Act and the rules. There's no prejudice of any kind to the 6 affected members with this weighty bundle. There was no response from Ms. Cupido. The insufficient time aspect, which is in paragraph 50, is a non-starter. My learned friend is quite correct. Item 1 of the schedule to the NA rule states that a notification must be delivered to the member at least 5 working days before the hearing. In the present case, the notice was delivered 8 working days before the hearing. I know that there's a debate whether it was 7 or 8 days, but that's not the point. The real point is it's more than enough time for what is regarded as a single incident. It's 6 members having been asked to leave the National Assembly for good or bad or indifferent reasons, jumping onto the stage in circumstances where the President of the Republic of South Africa and the Speaker of the National Assembly and other presiding officers were present in a particular manner. And there may be evidence to the effect of what objectively the inferences that this committee can draw. So we submit in conclusion, paragraphs 51, 52, and 53. The current application 52 for postponement has been brought for one purpose only, to delay the commencement of the inquiry on unsustainable grounds. It has not been brought in good faith. It has been brought at the 11th hour in what may legitimately be regarded as an ambush. The application for postponement must be dismissed. And we would conclude there, and I hope that I have complied with my 30 minutes. I think I'm on 29 minutes, Chair, but thank you.
Thank you, Initiator. Before I go back to the legal team of the affected member, I would like to check with honorable members whether you do have any clarity questions to the 2 presentations, both by the legal team of the affected member as well as the initiator. I'm allowing that space now for you, honorable members of the committee. Please assist me by observing hands, our officials, staff members, if there are any. If there is none, it's fine, we'll proceed. Delay, do we have hands?
Deputy Chief Whip, Chairperson.
Deputy Chief Whip, you are recognized.
Thank you very much, Honorable Chairperson. Good morning to yourself, the initiator, the affected members, legal team, and everyone on the platform. Honorable Chairperson, I want to welcome the presentations made by both sides. But I think it is our responsibility as members of Parliament to clarify some of the issues, even though the initiator has already done so. But we really need to emphasize this. Honorable Chair, I won't waste your time But just to indicate that this committee is not made up of ANC members. There are other parties, namely the ANC, DA, EFF, ATM, and IFP. And the rules of the National Assembly allow any member of parliament to participate in any committee, even if they are not members of those committees. So they allow for that. So any member of parliament is allowed to sit. And again, parliament, like any other institutions that are there, have its own arrangements. We are not a court of law. We are members of parliament. We have our own mechanisms. Our own mechanisms that we use. I think it is proper for us.
There is a point of order.
Oh, okay. My apologies, Chair. My apologies.
Yes, can you allow that point of order?
Honorable member. It would be helpful if you would chair this meeting, because you said you're calling for questions, not some narrative we're being given here. We must not be patronized. We know what this committee is. Why is she giving us a story? You said questions, and you must also stop sleeping there because you called for questions. Please.
It is not night. I'm not sleeping. Let us respect each other, because if I bounce back, you won't like that. Your point of order is sustainable. I was also going to respond to that other members must come up with clarity-seeking question. But thanks, because you alerted me that. But I observed that because the committee will still go and deliberate on that, and you are in order. But don't put any vulgar words which you won't allow me to do that to you. So let's respect each other right from day one. Thank you. Honorable Tlakote, honorable member is in order. You are trying to outline, clarify the rules, and the initiator has done so. According to me, as the chairperson, I was requesting clarity-seeking questions. If we don't have, let's leave it in that way, because we will still have time to go and deliberate in the committee. So with due respect, the honorable member is in order. What I don't like is to tell me that I must not sleep. I'm not your child. Thank you. Honorable Tlakote, can you stop there?
Thank you.
And then
Very much.
We'll go back to our legal team of our affected members to respond on the response by the initiator. Thank you.
Thank you very much, Honorable Chair. Order taken. Thanks.
Thank you, Chairperson. Let me start. I have 10 minutes, if I'm correct, Madam Chair.
Thank you, Advocate. You are right. You have got 10, but because you managed your time in the first round, I may allow you to add few.
All right.
I want you to be free, because here we're in the hearing, we're listening to each other. That all the room party pattern is being observed. Thank you, Advocate. You may proceed.
Thank you. Thank you, Chairperson. Let me start then with the first point I tried to make, and maybe I was not clear, and I take responsibility for not being clear. The point I make is that the committee is ANC dominated. According to our calculations, in its current composition, it is 61% ANC. 61%. Decisions have to be taken on 50+1, which means any resolution that has the political patronage of the ANC will be carried through. There's no one who can say anything about that. It's a fact that the ANC dominates this committee at 61%. It's even higher than the National Assembly composition of 57%. The question you have to ask yourself is whether any reasonable person acting reasonably will believe that EFF MPs, including its president and deputy president, that have been subjected to a disciplinary hearing for a political act will receive a fair hearing. That does not mean you yourselves are dishonest, but it means that you are perceived to be politically biased against the EFF, and it is your job to carry out the mandate of the ANC. That is what the judges have said. But where you are going to sit in judgment, that's the point. Where you are sitting in judgment of your political opponents, it is absolutely essential to remove the stigma of bias. Now, I said at the commencement of my address, Madam Chair, that the rule against bias applies. Mr. Katz has not responded to that. He must be taken to accept that the rule against bias applies. Number two, I said at the commencement of my address that you are bound by section 12, subsection 3, subsection A of the Powers and Privileges Act. What that section requires you is that you must inquire into the matter in accordance with a procedure that is reasonable and procedurally fair. So you have a duty to set up a procedure which would be reasonable and procedurally fair. In our view, the procedure that you must set up is the procedure where a judge, a retired judge, conducts an inquiry into the facts and finds out who did what. There is no provision here that you must substitute yourself as a fact finder. Your job is to conduct, in fact, your job is to inquire in accordance with the procedure. So item 1 is develop the procedure. Develop the procedure. And the first item on that procedure is make sure that there is an unbiased judge who's hearing the matter. He can recommend to, he can make findings of fact and recommend to you, and you can vote as you wish. But the fact-finding stage is the procedure that must be presided over by a judge. Now, Madam Chair, you've been here, we've all been here. Mr. Katz has never said that the procedure of appointing a judge will be unlawful. Why? Because he himself knows that a retired judge is a guarantee of independence and fairness. He himself knows that you cannot subject EFF MPs to a political machine of the ANC over a political act. Everybody knows this. You can ram through this, railroad it because you've got the numbers, but it will not substitute the cogency of the legal submission that you have to ensure that the procedure you adopt is reasonable and procedurally fair. Now, that does not mean as a fact you will be biased. It means you are perceived to be biased, and perception of bias is as good as actual bias. Number 3, Mr. Katz says, look at the rules. And then he cites Rule 154, 155. Those are irrelevant rules. You can close your eyes as far as those rules are concerned. The relevant rules are Rule 211, 212, 214. They talk about the composition of the committee. We have no objection to the composition of the committee. We've never said anything about the composition of the committee. Our only issue is who is going to conduct the fact-finding? Is it a judge or is it the political opponents of the EFF? Now, when you look, and Mr. Katz says, this committee is not going to make findings whether people are guilty or not. But that means he has not paid attention to Rule 214. Look at Rule 214. It says, 214(2)(b), the committee must table a report in the assembly on its findings, underline findings and recommendations in respect of any alleged contempt of parliament as alleged in section 13 of the Powers and Privilege Act. And then it says, C, if it is found that a member is guilty of contempt or misconduct, the committee must recommend an appropriate penalty from those contained in section 12(5) of the Powers and Privileges Act. So anybody who says that you have no power to make a guilty finding can only say so in ignorance of the rules. We say you should not be ignorant of your own rules. You must know your own rules that you must make the guilty finding. Our submission is the rules do not require you to sit as the disciplinary committee. They empower you to appoint an independent person to make the fact finding. so that there is no perception that the ANC is persecuting its political opponents. In other words, it's abusing its majority in parliament. So the debate about the rules is an irrelevant debate, completely irrelevant, because we've never said we want the rules to be struck out. We've never said we want the committee to be differently constituted. What we have said is the rules give you the power to appoint an independent judge in the same way as you've appointed my learned friend who is an independent initiator. Once you have done that, you will take the report of the independent judge, and thereafter you will deliberate and you will vote, and whatever the outcome of that vote is. But what will not happen, you are not going to have Mr. Malema being the subject of interrogation over a so-called misconduct, which is purely political, by his political opponents. That is the argument. And so far, I'm afraid to say there has been no answer to that argument. The only thing that has been done is we have been given the rules. We know the rules, we've read the rules. We could not have come here without having read the rules. We came here because we've read the rules, and we have said there is a way in which you can protect yourselves from acting unlawfully by appointing a judge. And nobody has said that the judge is not the correct person to look into whether Mr. Malema committed misconduct or not. And thereafter, you will vote. You still have your majority, and you can still decide what you want to do. And that it is wrong to say that there will be no guilty finding. The rules expressly use the word guilty of misconduct. Now, that's item number one. This idea that we are going to act fairly. We are going to act fairly. If a judge is biased or is perceived to be biased, he or she is removed before the case. The judge is not allowed to run the case, and after having run the case to say, oh, look at me, I've given you such a fantastic hearing. That is contrary to every rule that exists in the common law, in the Constitution, and elsewhere. The judge is removed at the beginning. We don't ask you to be removed. We ask for something less than that. We say, conduct the fact-finding before a judge, take the report, and we will go there, we will defend ourselves. So that's very, very important to understand what the point that is being argued is. In fact, it goes back, I think it was Honorable Hlakude. I heard from that question that maybe it was my fault that I didn't clarify what I was saying, and that is why she's going on a wrong track in assuming that I'm attacking the rules, instead of saying I'm asking you to enforce the rules, because the rules require you to act fairly, reasonably, and rationally. And I'm asking you that in order to act fairly, reasonably, and rationally, appoint a judge. And so far, no one has ever said why a judge should not be appointed. There can only be one motivation where a judge is not appointed. It's because certain people want to settle political scores. That can be the only explanation why a judge should not be appointed. We have so far had no explanation whatsoever. So we insist on our initial submission that we ask you with the greatest of respect, get a judge, and Mr. Malema will subject himself to an independent judge. And that does not diminish your standing. That does not diminish the autonomy of parliament. It retains it and it reinforces it. In fact, it even makes it more legitimate that you are prepared to say, let's get a judge, let's get advice, and then let's take it forward. By the way, this is not a radical thing that I'm suggesting. When you are disciplining yourselves, disciplining the public protector, you know the first thing you do? The first thing you do, you get a judge. You had Justice Ngabinde. You had, I think it was Justice Mohoro in the two matters. Even
advocate, sorry, your time is up, but I'm giving you 3 minutes to wrap up. Thank you.
Yes, all right. So that's on the first issue. Let me leave that. I wanted to make the two examples. Public protector, you've got a judge who makes the first determination and then it goes to parliament. So that's nothing new. Then let me go in the 3 minutes that is left to the issue of postponement. My colleague says, we left it too late. You know, Madam Chair, I don't know if you have this bundle of the postponement application in front of you. If you have it, I will ask you to go to page 39 and 40. We wrote a letter to, not me, but my attorney wrote a letter to Parliament on the 10th of November. And they said, look, can we please get this thing postponed? The state attorney, now that is Mr. Katz's client, instructing attorney, wrote back at paragraph 7, they said, we point out that it would be premature and an abuse to approach a court without first approaching the Powers and Privileges Committee with whatever complaint your clients may have regarding the notices and charge sheets that were served. So they said they cannot give us an answer. We must come to this committee to request the committee. Now, Madam Chair, listen to this. When we come to the committee, they say we came to the committee too late. They themselves said they couldn't give us an answer. The state attorney said, I can't give you an answer, go to the committee. Today we are in front of the committee. What are we being told? We are being told we came too late. So there is a fundamental inconsistency that is being played by the state attorney side. Then the last point to be made goes into the issue of Stalingrad. I have never seen a case where an application is made for the first time and where there is a commitment to hear the case in a month. I've never seen that case being reduced into Stalingrad. It's the first time. And so you have to be careful not to be hoodwinked by fancy terms, Stalingrad. It applies to Mr. Zuma's case, the judges have found. It doesn't apply to Mr. Malema's case. And Stalingrad applies in criminal cases and it doesn't apply in parliamentary proceedings. This is the first application, and we have said we are going to be back in January. We need about a month to prepare. And then somebody jumps Stalingrad. You have to be taken seriously in your job as parliamentary MPs. So, in summary, we say, appoint a judge, we will appear. Number two, we say, give us time. We need about a month to consider this. The submissions have been circulated, I'm told, for the benefit of the committee. Thank you, Madam Chair. I hope I have stayed within the extra 3 minutes.
Thank you, Advocate. Indeed, we have done so. Thank you so much. Honorable members, our initiator, the legal team of the affected members, thank you so much. I want to now inform the August House that I'm intending that we suspend the proceedings of the hearing in order for the members of the committee to meet as a committee. We'll suspend it for 1 hour and then we'll resume again today. So the difference here features is that the meeting of the committee is that only members of the committee will participate in the deliberations about the matter presented before us. The affected members, their legal team, and the initiator will not participate in the deliberations of the committee. So the hearing is now suspended. Thank you.
Thank you. Yes, Chair, the meeting has a quorum, Chair, so that it can proceed.
Again, are the only members of the committee which are here as ruled by the chair in the previous hearing.
Another thing, Chair, we have M46. We don't know who is M46.
Yeah, that's
Chair,
why I'm saying let them assist us. Yes.
We have only members of the committee on the platform, and Chair, M46 is not a person, Chair. It's just the link.
Again.
Chair, M46 is just a venue for connecting. It's not a person.
Okay, it's not a link. I get you. Yes.
Chairperson, sorry, this is Honourable Lottery. I am concerned because on the participants list, it says M46 and there is a video, so the link is live. Is what we saying now audible in M46?
Yeah, that's what members want to be sure about this. Can we be assisted by our staff members there? That's
Yes,
why my request was
Chair.
to have a new link as the committee for this for this 1 hour, and then we go back to the hearing if it is possible to the previous link. Can we do that?
At the venue, there's only the staff, the procedural staff that supports the committee. The legal teams have gone out. So on the platform, it's only the members of the committee who are on the platform. The affected members are not on the platform.
The first request of postponement. It's very clear that we're being subjected to a kangaroo court, and which we're not going to accept. And you brought this white man here to come and persecute us, because you know that every white man will go after the blood of the EFF.
But the honorable member who has just spoken, her concern is that this venue is connected, is live. So that's what she was saying. Can you assist us on that one so that we can be able to start? Because I want to guarantee members and to be at the same page, all of us. Honorable Lodrick, are you answered?
Public meeting. Remember, Chair, this is a public, it's not a private meeting. The default positions in terms of our rule, meetings of the committees are public. So the meeting has to be broadcast. It's open to public. Members of the public who wants to sit here and follow proceedings, they can do so.
Okay. I'm sure everyone is now answered. We'll proceed. As I have indicated, can we deal now with the input, whether we grant or not grant, state reason, whether we do grant the application or we do not grant the application. The floor is open for your input, honorable members. I believe all of us were now answered.
Dr. Lottery's hand is up. Ms. Majosi's hand is up. Deputy Chief Whip of the Majority Party's hand is up, Chairperson, in that order.
Thank you, Dr. Lodrick. The stage is yours.
Thank you, Chairperson. Chairperson, in terms of the postponement application, I am of the opinion that it should not be granted. I think everything has been set down. The initiators have been prepared. They have, they know exactly what to do. I am quite sure that the affected members, legal team also has access to all the information. So from my side, I would not support a postponement. We have the fact that it's the end of the term almost, and I'm sure it will be difficult to get the legal teams with specific dates again. They are available now for this week. Thank you.
Thank you, Dr. Honorable Majos.
Thank you, Chairperson. Let me greet the chair and all honorable members. I think I will also fall on the previous speaker. Why? Because the argument that they are bringing, it says, Chair, that they are willing to come to the committee when we appoint an independent judge. And they are telling us about our own rules, which does not accommodate that. So by the look of things, whether we postpone or not, which means they are not going to come and appear into the committee without that independent judge. I might not be privy to the previous discussions and the previous meeting, but I got the presentation from the advocate that is arguing, and Chairperson, I think because we have given them enough time and all documents were sent and everything that they needed all in due time, and they came here because they were supposed to appear to the committee, not because of they would want the committee to postpone due to the fact that we must appoint an independent judge and make references to the public protector and all sorts of other institutes. We are not speaking of institutes that are entities of government, but we are here as the Committee of Powers and Privileges and dealing with members of the parliament. We are not dealing with extended members who are appointed maybe or so forth. We are all dealing with members of parliament. So I don't think it's correct, Chair, that we must postpone. It must the hearing must continue, and if this is our fourth term, the previous speaker has said, and we are only closing now. If they want a month, which means it's going to be 2 months, because then which means we must come back in January, and we must now still go back and argue the fact that we must have an independent judge, of which I don't believe that we should do that, and we must be mandated by an advocate that that is what we must do as members of parliament. We know our rules, we have followed them, and I think we must follow suit and make sure that this hearing sits. Thanks, Chair.
Thank you, Honorable Major. Honorable Zakode.
Thank you very much, Honorable Chairperson. Good afternoon, honorable members. Listening to both presentations by the initiator and the affected members' legal reps, Honorable Chairperson, one came to the conclusion that this is indeed, as the initiator has said, it's a parliamentary process. We are governed by our rules. We have a responsibility to sit in this committee and deal with our own internal arrangements. So, Honorable Chair, I want to agree with my colleagues who have spoken before me that the issue of hiring or getting an independent judge to run this process doesn't arise anyway, because this is a parliamentary process. It is not for the first time that the Powers and Privileges Committee have to sit and deal with matters like this. We've been dealing with that ever since this Powers and Privileges Act was adopted. So we will proceed with the work that is before us. The issue of an outsider chairing a parliamentary committee meeting is neither here nor there. They are entitled to their views, of which we are not going to say they shouldn't say what they believe is what should happen. So, but us as Parliament, we have a responsibility according to the rules and also according to the Powers and Privileges Act that we must be composed and as a committee deal with whatever is referred to us as a committee. Like I said earlier, that Rule 185 of the National Assembly rules allows for any member of parliament to sit in any committee and participate, except for when it comes to voting. Those members cannot vote, but participating, they are allowed to do so. So, Honorable Chair, I just want to say this application for postponement is not accepted, as the other honorable members have said, and also we cannot accept our responsibility as a committee to other people. So this is our work, we'll do it. Thank you.
Thank
Chair,
you, Honorable.
other members that have hands.
Yes, can we recognize them?
Dr. Klape and Mr. Kaba.
Dr. Tlape, Honorable Dr. Tlape.
Thank you, Chair, and greetings to the members of the committee. Chair, I support the honorable members that spoke before me, and I'm also taking my submission from the arguments that has been made before this committee this morning, particularly from the initiator, Chair. One is that the postponement has no relevance. If we have to develop a process, it's for this committee to say the process will be undertaken by this committee according to the rules that it has, or that it will have been set by the committee or has been set for the committee. I must also, Chair, register my displeasure for the affected members or their representative to wanting to reduce a committee of parliament to members of the ANC. That should be not allowed or tolerated. And like the initiator has said, even the court sitting that they're arguing that is sitting on the 4th of December has got no issues with this. Court has always said to go through your hearing process. If you're having challenges or you are not satisfied, you can then approach the courts. So there's no relevance in terms of postponement, Madam Chair. Thank you.
Thank you, Dr. Tlape. Honorable Kaba.
Yeah, thank you, Chair. I think also, Chair, in welcoming as the presentation is done, also from the initiator, let me join other members to also say that the application should not be allowed. The hearing must indeed continue. And I join other members too, also, Chair, to say the behavior and the mistreatment that was done to you really is not welcome. I think we remain shut to respect the proceedings. However, it is important that we support you, Chair, and we respect your authority. For other members who may have misbehaved in any other manner, I would employ on you, Chair, to really be hard where necessary rules of Parliament applies. Chair, no postponement. The hearing must continue. Thank you.
Thank you, honorable members. Do you still have any other hands?
No, Chair. Those were the only hands.
My hand is up. Desiree van der Walt.
Who's that?
Honorable van der Walt.
Van der Walt.
Chair, I don't want to be repetitive, but I fully support the proposal by Dr. Lottreed. I think if one applies one's mind and you read the documents and listen very carefully, that is the way to go. And I would also just like to add to say that the tone of people during the previous part of the meeting is unacceptable for members of Parliament, and especially to you as the chair, and as well as to the initiator. Thank you, Chair.
Thank you. Thank you, honorable member. Any other hand? No other hands.
All, Chair.
No any other hands. The majority view is that no postponement should be granted. So that's the decision of the committee. And then we'll put the charges to the affected members.
Chair.
Yes, Honorable Dozi.
It's Honorable Malema.
Oh, Honorable Malema, sorry. Over to you.
Thank you very
Honorable.
much. We heard your response, and we don't agree with it because we believe that in every situation like the one we're faced with now, there will never be a refusal to grant a first request of postponement. It's very clear that we're being subjected to a kangaroo court, and which we're not going to accept. And you brought this white man here to come and persecute us because you know that every white man will go after the blood of the EFF. That's what he's there for. I don't care whether my legal representative says he's got respect for him. I've got no respect for him. He's a DA lawyer. He's a well-known DA lawyer who's here
Honorable
looking
Malema,
for
Honorable
our blood.
Malema, can you make your point?
And we're not
rather
going
than
to accept that. I'm making a point. You can't tell me how to speak. I'm making a point.
I'm requesting you not to be personal.
I'm
Respond
personal.
to the.
You can't tell me what to say. I can't tell me what to say. Let me make my point, and then you can rule me out if you want.
So all I'm saying is you brought an apartheid apologist and beneficiary to come and persecute me. No white man can persecute me. I'm not going to allow that. And no white man will persecute the EFF. And we're not going to accept to appear before this white man and before this kangaroo court. You can go and be together in your own arrangement there. We are not going to participate in this kangaroo court because its outcome has been determined even before by yourself and the DA. That's why you brought a DA lawyer here to come and speak to us. He's not a man of integrity. He has got no integrity to can persecute us and will never be persecuted by a white man. We refuse to appear before a white man. We refuse to appear before a kangaroo court. Do what you want to do. Some of you won't come back to this parliament, especially you, Chairperson, and many of you. You are going to watch parliament from home. Whatever decision you take will still be in that parliament, whether that white man you called likes it or not, we will be in parliament. As a result, we recuse our legal representatives. They must now leave that place, and we're also leaving this nonsense of a kangaroo court. Thank you.
Thank you, Honorable Malema. That's your view. Myself, as the chairperson, I don't care whether I come back or not, but I'm chairing this session. I'm proceeding with the hearing. My ruling has been, the decision of the committee is that we refuse the postponement and we are proceeding. I will now call upon the initiator to proceed as requested, to put the charges to the affected members.
And my learned friend has asked me for an opportunity to address the committee, and I have no objection to my learned friend doing so.
Thank you. I know, Madam Chair, that you're quite keen for the charges to be placed. I'm sure that will happen in a moment. I just want to note two aspects on the legal side. Mr. Malema has addressed the politics of the matter. The first one is we would like the transcript of the deliberations. Someone told me that they had listened to the deliberations. I think they were available on YouTube. There is a disjuncture between the deliberations and the ruling that has been given. So we would like to scrutinize that quite carefully. So we would like the raw data of what was discussed, because it doesn't seem to tie up with what has been delivered. That's number one. And then number two, we just note that we also asked for a ruling on the appointment of a judge. There has been neither deliberation nor decision on that issue, but both of those matters, we would like to take them up in the Western Cape High Court. But at this point in time, we would simply like the actual transcript of the deliberation. You have also heard that my client has excused me from the hearing, but I have to give due deference to the committee to indicate that in the absence of a client, I have no mandate to remain. My juniors also have no mandate, and my attorneys have no mandate. So if I pack my bags, it's because my client has instructed me to excuse myself. But I still need to get the final word from yourself that I can pack my bags.
Advocate Loroka Toby, you are leading the affected members. I don't think that I've got powers to can instruct you to do that. It's your right with your affected members to take a decision. The ruling made by the chairperson is the deliberation and the decision of the committee. I'm not a committee member alone, so I won't evenly say that go or do not go. My surprise is that you are leading them and you are representing them, but the decision have been done by the affected members rather than yourself. So I don't have any obligation to can say you stay or you do not stay. The ruling of the committee still stands. We are proceeding. Thank you.
Yes, Madam Chair, I understand that, but the point is that I don't want tomorrow that there is an issue that I acted in contempt of the Parliament or the committee. So that's the only point I'm making there, to say, look, you've heard my instructions, and but if you say you are neutral on the subject, then there's no problem.
I'm now addressing the hearing. As I've indicated that the ruling has been made and still stands, I'm proceeding. I'm now requesting the initiator to put the charges to the affected members.
Thank you, Chair. I'm not sure, but I think our learned friends are intending to vacate the hall at this point, and perhaps they should just be given an opportunity to do so, as I understand it.
Yes, I may. Yes, you are right. Let's allow that process to unfold. Thank you.
Thank you.
Thank you, Chair. And I note that the legal representatives of the affected members have all left the chamber, and it is for me to now put the charges to the 6 affected members. But in doing so, perhaps I should preface what I'm about to do with just pointing out that item 7 of the schedule, which deals with the procedures for this committee, Schedule 7 to the rules, gives members the right to be present. It doesn't oblige them to be present. And because they were given that right and have chosen, they've made an election to leave for the reasons they've articulated, I just wish to refer to one case, but the issue is not difficult to understand, but it's one case from the Labour Court in Johannesburg of November 2021. And the name of the case is Futshane, F-U-T-S-H-A-N-E versus Millard, N-O and others, square bracket 2021, square bracket ZALC JHB 432, 3 November 2021. And in paragraph 24, the point is made in a labor context that once an employer institutes disciplinary action and gives the affected employee notice thereof, it is open to the employee to attend or to refuse to attend the inquiry. Should the employee refuse to attend the inquiry, such employee must be prepared to accept the consequences thereof, one of which is that the inquiry will proceed in his absence and adverse findings may be made. And that principle is not one which has not been accepted throughout South Africa when it comes to labor, disciplinary matters, or any other type of admin action. If a person has a right to attend, they choose not to exercise that right, they take the consequences, whatever they may be, of exercising that choice. So now I turn to the charges, and the committee will know that because the affected members are not present, the chairperson may or must. I'm told, Chairperson, that one of the 6 affected members is still on the platform, and the question that has been put to me by the parliamentary advisors is that they're not sure that's proper for one of the affected members to remain on the platform in circumstances when they've taken a decision to not be present during the hearings for the reasons that they've articulated. So perhaps, Chairperson, I would ask for a ruling on that issue.
Thank you, Initiator. Can the member be removed from the platform, please?
Yes, apparently that member has been removed. And I now turn to the charges. The first charge that I wish to put is to, and perhaps I should just go in the order in which the notices of hearing have been dealt with. And the first charge is to that of Honourable Member Malema. And I'm going to read the preamble to the charges, and then I will ask that the Chair make, as she is required to do, a plea of not guilty into the record on behalf of each of the members after I've read the 6 charges in respect of each of the 6 affected members. So the preamble starts off, I just want to make sure that I do it in the correct order, to Honourable Member Malema. Preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address, SONA, by the President of the Republic of South Africa in terms of order paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Shivambu, Mr. Pambo, Mr. Dlamini, Dr. Nodlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa, the President, and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the Security Services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of section 13A and C, read with section 7A and E of the Powers and Privileges and Immunities Act of Parliament and Provincial Legislatures Act 4 of 2004, and the National Assembly Rule 654A and D, Rule 69A and F, in that as a Member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of section 2(1)D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by 1, acting with Mr. Shivambu, Mr. Pambo, Mr. Dlamini, Dr. Nodlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Those are the charges to Mr. Malema, Chair. And your job, as we understand it, Chair, is to put in place of the explanation or plea by the affected member a plea of not guilty. Ask Chair that you register and record a plea of not guilty on behalf of Mr. Malema, Honourable Member Malema.
Yeah, thank you. I'm registering that on behalf of Honourable Malema, a plea of not guilty. Thank you.
Thank you. I now turn to the second person to be charged, and I'm going to refer the charges in respect of Dr. Nodlozi, and that reads similarly to the charges against Honourable Member Malema. And I'll start off with a preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Union Address, SONA, by the President of the Republic of South Africa in terms of Order Paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Pambo, Mr. Lamini, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct as particularized above resulted in a suspension of the proceedings and your removal from the House by the security services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004 and National Assembly Rule 64A and D, Rule 69A and F, in that as a Member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 2(1)D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder and disruption in the House and acted in a way which was seriously detrimental to the dignity, decorum and orderly procedure of the House by acting together with Mr. Julius Malema, Mr. Shivambu, Mr. Nico Floyd Shivambu, Mr. Pambo, Mr. Lamini, and Mr. Tambo. You ascended onto the stage without the authority to do so and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Yeah, those are the charges put to Dr. Nodlozi.
Thank you. I now present on his behalf a plea of not guilty.
Thank you, Chair. I now turn to Mr. Shivambu. Preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation Address, SONA, by the President of the Republic of South Africa in terms of Order Paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Pambo, Mr. Lamini, Dr. Nodlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct as particularized above resulted in a suspension of the proceedings and your removal from the House by the security services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004 and the National Assembly Rule 64A and D, Rule 69A and F, in that, as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 21D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Pambo, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so, and in a threatening manner approached the President of the Republic of South Africa and the presiding officers, and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of the proceedings. The charges put to Mr. Shivambu, Chair.
Thank you so much. On his behalf, I enter a plea of not guilty.
Chair, I turn to the charges to be put to Mr. Tambo. I'm going to read the preamble. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address, SONA, by the President of the Republic of South Africa in terms of order paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Pambo, Mr. Dlamini, Dr. Ndlozi, ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the security services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you're guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004, and National Assembly Rule 64A and D, Rule 69A and F, in that, as a member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 2(1)D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Shivambu, Mr. Pambo, Mr. Dlamini, and Dr. Ndlozi. You ascended onto the stage without the authority to do so, and in a threatening manner approached the President of the Republic of South Africa and the presiding officers, and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Chair.
Thank you so much. And now enter a plea of not guilty on his behalf. Thank you.
Thank you, Chair. I'm turning to the fourth person to be charged. That's Mr. Pambo. And again, I read the preamble to the charges. On 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address by the President of the Republic of South Africa in terms of order paper JS 2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through the mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo, ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the Security Services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004 and National Assembly Rule 64A and D and Rule 69A and F. In that, as a Member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 21D of the Act, where the business of the day was the State of the Nation address by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder and disruption in the House and acted in a way which was seriously detrimental to the dignity, decorum and orderly procedure of the House by acting together with Mr. Malema, Mr. Shivambu, Mr. Dlamini, Dr. Ndlozi, and Mr. Tambo, you ascended onto the stage without the authority to do so, and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of proceedings. Chair, that was the 5th person to be charged, and it's now called upon you to enter a plea for that person.
Thank you. I must enter a plea of not guilty on his behalf. Thank you.
And I turn to the last person to be charged, Mr. Dlamini. Again, the preamble to the charges on 9 February 2023, there was a joint sitting of Parliament where the business of the day was the State of the Nation address by the President of the Republic of South Africa in terms of order paper JS2-2023, the joint sitting. It is a significant national event and was attended by members of Parliament, foreign dignitaries, and the head of the judiciary. It was viewed through mainstream media and social media by millions of people in South Africa and the international community. During the joint sitting, you, as well as Mr. Malema, Mr. Shivambu, Mr. Pambo, Dr. Ndlozi, and Mr. Tambo ascended onto the stage without the authority to do so and advanced towards the President of the Republic of South Africa and the presiding officers in a threatening manner. Your conduct, as particularized above, resulted in a suspension of the proceedings and your removal from the House by the security services of the Republic of South Africa. Charge 1, contempt of Parliament. It is alleged that you are guilty of contempt of Parliament in terms of Section 13A and C, read with Section 7A and E of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act 4 of 2004 and National Assembly Rule 64A and D, Rule 69A and F, in that as a Member of Parliament and during a joint sitting of the Houses of Parliament on 9 February 2023 at City Hall, a precinct of Parliament in terms of Section 21D of the Act, where the business of the day was the State of the Nation addressed by the President of the Republic of South Africa, you deliberately created and took part in a serious disturbance, disorder, and disruption in the House and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House by acting together with Mr. Malema, Mr. Shivambu, Mr. Pambo, Dr. Ndlozi, and Mr. Tambo. You ascended onto the stage without the authority to do so and in a threatening manner approached the President of the Republic of South Africa and the presiding officers and had to be physically removed by security services of the Republic of South Africa, resulting in a suspension of the proceedings. Chair, that's the last charge that I put to one of the affected members.
Thank you. I now enter a plea of not guilty on his behalf, on behalf of Honorable Shaman. Thank you.
Thank you, Chair. Chair, with your permission, I would be inclined now, and I propose to call a witness on behalf of the initiator. The person is Mr. Klaxo, who is the Secretary to the National Assembly. With your permission, Chair, I ask that he be sworn in so that he may give his evidence concerning the charges put to the 6 affected members. Thank you, Chair.
Thank you. Rules 168 requires that before a witness gives evidence before a House or committee, The chairperson must, in accordance with Section 16 of the Powers and Privileges Act, inform the witness as follows. Open quote. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, there is noise. IT, can you assist us? There are some background which are not fine. Thank you. You are, however, protected in that evidence given under oath or affirmation before a house or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. So, based on this provision of Rule 169, I now checking with our witness whether he has got any objection to take any oath or making an affirmation.
Chairperson, I have no objection to taking the oath.
Can you raise your right hand and say this after me? I swear that the testimony or evidence I'm going to give is the truth.
I swear that the testimony or evidence I'm going to give is the truth.
And only the truth.
And only the truth.
So help me God.
So help me God.
I confirm that the testimony or evidence I'm going to give to this, the truth and only the truth, and binding on my conscience. I am now recognizing the initiator, Advocate Kasi, who will present the evidence regarding the allegations.
Thank you. Thank you, Chair. Mr. Klaasel, could you explain to the committee your employment position in Parliament? And when you do so, if you could explain somewhat of your history within the precincts of Parliament and your employment history. In other words, your CV and how you find yourself in employment today.
Chairperson, I am Secretary to the National Assembly. I have been in this position since 2013. However, I've been employed in Parliament since 1994, and